Good morning, everybody. Week 7, it's here. November is here. I don't know where the time has gone, but we better make the most of what's remaining because this is our next to last week. And before I get into the substance of this week, which is civil litigation, let me remind you that if you have work that hasn't yet been submitted, please check to see what that work might be and go ahead and submit it. It doesn't matter that it's late. Even the work that will receive a penalty for being late will only receive a 1, 2, or 3-point penalty. And it's so much better for you to submit your work late than not to submit it at all. So I really strongly urge you to check and see what you're missing and go ahead and get it in. I'm more than happy to grade it. All I want you to do is put it in so I can grade it. Now, with that little cheer dispensed with, let's get to the substance of this week's module, which is civil litigation. Now, up to this point, we've naturally been concerned with criminal matters, criminal litigation, criminal process, criminal procedure, constitutional issues, etc. Here we're switching gears, and we're switching gears enough so that I need to remind you of the difference in terminology between criminal cases and civil cases. In criminal cases, as you know, the parties are the state or federal government, and that's called the prosecution, and the individual or sometimes corporation who has been charged with a crime, and that's the defendant. Now, confusingly, in civil litigation, we have two parties as well, but they're called, instead of the prosecution, the person who brings the suit is called the plaintiff, sometimes the complainant, but for the sake of simplification, in our discussions and writings, we'll call that person the plaintiff, and the responding party, who is also called the defendant, confusingly. But keep in mind here that the plaintiff and the defendant are individual people. They're not governments. So we have an individual person suing another individual person. And when I say person, please know that that also encompasses corporations and partnerships. But for simplicity's sake, we'll say person. An individual person, a plaintiff, is suing another individual person, a defendant. The goal of that lawsuit is not to punish the defendant. That's the goal of a criminal prosecution. In civil litigation, our goal is, the plaintiff's goal is to be compensated by the defendant for harm that the defendant has caused to the plaintiff, and that harm is translated into a certain loss in terms of dollar amount. In the law, in civil litigation, we don't have supernatural powers. We have only the power of translating a loss into a dollar amount and ordering that the defendant pay that dollar amount to the plaintiff. Now, sometimes that loss is tragic. Sometimes a person has died or a person has been severely injured. Obviously, we don't have magical powers in the law. We can't order the defendant to bring a person back to life or to reattach an arm that's been severed or to restore sight to somebody who's been blinded. That's clearly impossible. What the law can do is try to determine what the dollar value of that kind of loss is, and to order the defendant, once the plaintiff has proven the defendant is at fault, to pay the plaintiff that dollar amount. That's the goal of civil litigation. It's not revenge, it's not retribution, it's not punishment, it's compensation. Okay, so with that in mind, how does the plaintiff go about linking the defendant's actions to the loss that the plaintiff has suffered? Well, that linkage is achieved through the process of discovery, which is a process that allows both parties, plaintiff and defendant, to find out as much as possible about exactly what happened that led the plaintiff to file this lawsuit in the first place. The plaintiff wants to find out as much about the defendant as possible, about the defendant's actions, about the defendant's history, the defendant's character, the defendant's actions, and maybe weaknesses that can be found out. And on the other hand, the defendant wants to find out the exact same things about the plaintiff, because sometimes it's not a clear-cut case of a purely innocent, wonderful, angelic plaintiff bringing suit against a horrible, evil, devilish defendant. Most of the time we operate in shades of gray, as we do in every other aspect of life. Civil litigation is not about labeling, well, it sort of is about labeling one person as bad and the other person as good. That's the goal of the lawyers on both sides. But the truth is that the civil litigation process works in a gray area in which neither party is wholly innocent and neither party is wholly guilty, even though I shouldn't be using those words, because innocence and guilt are not the operative factors in civil litigation. It's responsibility and liability, or lack of responsibility and liability. Those are the concepts that apply to civil litigation. So in reading this week's materials, you're going to be exposed to that terminology that I've just talked about, and you're also going to be dealing with some of the practical aspects that we've been talking about in the last week, which is the mechanics of calendaring and docketing civil cases. Now here in civil litigation, we have one big factor that applies to criminal litigation that's just been tossed out of the window, and that is the constitutional requirement for a speedy trial. There's no such constitutional requirement in civil litigation, which is why civil dockets stretch for years. Civil cases sometimes take years, or even in many cases decades, in order to be resolved or brought to trial. Courts don't like that. Judges don't like that. And so what they do when a civil case is filed is set certain schedule of pretrial conferences in order to encourage the parties to complete their discovery process within a reasonable time, and then to settle the case out of court. The vast majority of cases, both state and federal, civil cases, are settled out of court. They never get to a courtroom. The parties don't even want them to get to a courtroom. Not really. It's very expensive to complete a civil trial. The best thing for all parties, in most cases, not all, of course, but in most cases, the best thing for both parties is to settle the case out of court, to work together, either literally attorney to attorney, not really party to party so much, but attorney to attorney, or through a mediator or sometimes an arbitrator. Now, that's not a faultless process. We're not even going to get into it really this week. There isn't time, but be aware that very often civil litigation goes through a mediation process. That is to say, an out-of-court meeting with a third-party referee, more or less, who will help the parties to work out a settlement between them. Now, I won't get into that too much because I'm going beyond the material in this week's module, but keep it in mind, and if you have questions for me about civil litigation, if you have questions about the material or anything that might occur to you that's not in the material that you're curious about in terms of civil lawsuits, please ask me. Ask me in the general discussion board or in our discussion board that we deal with within the module itself. Okay, I'm going to be quiet now because I've gone over 9 minutes. That's too long. You don't have time to watch these long videos that don't have, interesting chase scenes and violence. So I'll be quiet and I'll talk to you later, and I'll see you in our discussion boards. Have a great week. Bye.